And Grammys host Trevor Noah landing himself in hot water with the U.S. president for a joke he made on air about Donald Trump's alleged relationship with Jeffrey Epstein.
That is a Grammy that every artist wants, almost as much as Trump wants Greenland, which makes sense. I mean, because Epstein's island is gone, he needs a new one to hang out with Bill Clinton. So, oh, I told you it's my last year. What are you going to do about it?
So let's unpack what just happened at the Grammys and why it's spiraling into yet another legal threat from Donald Trump. The moment itself wasn't shocking. Trevor Noah, hosting the event, delivered a series of jokes, as hosts do. Political jabs are nothing new at award shows, but what followed was entirely predictable.
So Trump then took to his social media platform following the Grammys, calling the show, quote, unwatchable. He then went on to defend himself, saying he had never been to Epstein Island. The president wrapped up his post by threatening legal action against Trevor Noah.
Trump took to his social media platform afterward and blasted the Grammys as unwatchable. That alone wasn't surprising. What raised eyebrows was that in the same post, he pivoted to defending himself against Epstein-related implications and then floated the possibility of suing Trevor Noah. Now, here's where things get interesting. No lawsuit has actually been filed. What we have right now is a public threat, and Trump is not new to threatening litigation. He has a long history of filing lawsuits, threatening lawsuits, or using legal pressure as a political weapon. Sometimes those cases move forward. Sometimes they collapse quickly.
He said that I spent time on Jeffrey Epstein's island. I didn't. I mean, he's a lightweight, this guy. He's a terrible, I think he's terrible. I thought he did a terrible job at the Grammys. I thought the whole Grammys was terrible. I watched part of it. It's not watchable. But he was a lousy host. I'd say not as bad as Jimmy Kimmel, but pretty close. And no, he made a statement about me and Jeffrey Epstein. I have nothing to do with it.
But the threat itself often functions as a tactic, a warning shot meant to chill speech. To understand whether this would even remotely hold up in court, you have to understand defamation law. There are 5 core elements typically required to prove defamation. First, there must be a false statement purporting to be fact. Second, that statement must be published to a third party. Third, there must be fault amounting at least to negligence. Fourth, the statement must be defamatory. And fifth, there must be damages. When the person claiming defamation is a public figure, and Donald Trump is about as public as it gets, the standard rises significantly. He would have to prove actual malice. That's not everyday malice in the sense of hurt feelings. Actual malice in the legal sense means the speaker either knew the statement was false or acted with reckless disregard for whether it was true. That is an extraordinarily high bar. The Supreme Court has repeatedly held that satire, parody, and comedy fall under protected speech. Artistic expression receives strong First Amendment protection. The courts have made clear that audiences understand comedians exaggerate, hyperbolize, and riff. Comedy is not treated the same way as a factual news broadcast making direct claims. So,
Minaj is not here. She is not here. She is still at the White House with Donald Trump discussing very important issues. Actually, Nikki, I have the biggest ass. I have it. Everybody's saying it, Nikki. I know they say it's you, but it's me. Wop, wop, wop. Look at it. Look at it, baby.
what exactly did Trevor Noah say? He made a joke tying together Trump's interest in Greenland with the idea that Epstein's island was no longer available, adding a punchline about needing a new island to hang out with Bill Clinton. He did not state, as a matter of fact, that Trump had been on Epstein's island. He did not present evidence. He did not frame it as reporting. It was structured as a joke. For Trump to prevail in a defamation claim, he would have to convince a court that a reasonable viewer interpreted that joke as a literal, factual assertion. Then he would have to prove that Trevor Noah knew it was false and intended to harm him. Then he would have to show reputational or financial damages resulting specifically from that joke. That's where it gets complicated. Trump's reputation has already been the subject of massive public debate for years. The Epstein files, media reporting, past lawsuits, criminal proceedings, investigations, all of that exists in the public sphere, demonstrating that one comedic remark materially damaged his reputation would be extremely difficult. You would have to isolate measurable harm directly caused by that specific joke. Financial damages would be even harder. Has Trump lost money because of a Grammy joke? Did a business deal collapse? Did donors withdraw funding? Did measurable income decrease? In civil litigation, damages cannot simply be speculative. They must be demonstrated. Then there's the actual malice standard. It is not enough to say the joke was offensive. It is not enough to say it was mean. The plaintiff must show that the defendant either knew the implication was false or recklessly disregarded its truth. When dealing with comedy, courts are especially cautious. Satirical implications are generally understood as commentary, not literal claims. Trump's history with defamation suits is also relevant context. He has previously sued Hillary Clinton and others in cases that were dismissed. In one high-profile instance, a court ordered him and his attorney to pay nearly $1 million in sanctions after determining the lawsuit was frivolous. While that doesn't create binding precedent for future cases, it does shape judicial perception. Judges are human. Patterns of litigation behavior matter in credibility assessments. Now let's talk about strategy. Would Trump sue only Trevor Noah? Or would he include CBS or the network responsible for broadcasting the Grammys? In civil litigation, plaintiffs often name multiple defendants to broaden potential liability and increase settlement leverage. Networks have deeper pockets. Including a corporate defendant can change the pressure dynamics. CBS might evaluate the case differently than an individual comedian. Corporations sometimes settle to avoid prolonged litigation costs and reputational distraction. That doesn't mean the case has merit. It means the cost-benefit analysis differs. A comedian might relish the fight. A network might calculate differently. But there's another layer to consider: discovery. If Trump were to file suit, he would open himself to depositions, interrogatories, and sworn testimony. Discovery is not a one-way street. Plaintiffs get questioned too. Trump would likely have to sit for a deposition under oath. He would face detailed questioning not just about the alleged damages, but potentially about his prior statements, his knowledge of Epstein, his public comments, and the context surrounding the joke. Depositions can be risky. They are conducted under oath. They are recorded. In past civil proceedings, Trump has struggled during depositions. Every answer can be scrutinized. Every inconsistency can be exposed. Filing a lawsuit means accepting that risk. It also invites counter motions. Trevor Noah's legal team could file a motion to dismiss early, arguing that the complaint fails to meet the legal threshold. They could potentially seek anti-SLAPP protections, depending on jurisdiction. Anti-SLAPP statutes are designed to prevent lawsuits intended to chill protected speech. If the court found the lawsuit was primarily an attempt to silence commentary, Trump could face attorney fee awards. There's also the public optics. A former president suing a comedian over a Grammy joke reinforces certain narratives about sensitivity to criticism. Political figures are routinely mocked in American culture. Courts have long recognized that robust debate, including ridicule, is part of democratic discourse. The actual malice doctrine exists precisely to protect commentary about public officials. Without it, journalists, comedians, and critics would operate under constant legal threat. Now, consider the reputational question. Can Trump argue that being associated with Epstein implications damages him uniquely because he has publicly denied certain allegations? Perhaps that would be the framing. But the legal system demands evidence, not emotional reaction. And then there's timing. Litigation takes months, sometimes years. By the time any case reached trial, the news cycle would have moved on repeatedly. It's entirely possible that the threat itself is more valuable politically than the lawsuit would be legally. Legal threats can energize a base. They can generate headlines. They can reinforce a narrative of persecution. Filing an actual complaint subjects the matter to judicial scrutiny. Sometimes the threat is the message. There's also the reality that satire cases have been litigated before. The Supreme Court's decision in Hustler magazine versus Falwell set a powerful precedent protecting parody. In that case, the court held that public figures cannot recover for emotional distress from satirical content without proving false statements of fact made with actual malice. That case looms large over any defamation claim arising from a joke. Let's address one more angle: damages to net worth. Trump is currently engaged in massive financial claims against various entities. He has sought enormous sums in different lawsuits. To argue that a Grammy joke materially harmed his finances would require a level of specificity that seems implausible. Market data, business valuations, contracts, all would be examined. And what if, hypothetically, his net worth increased during that period? The damages theory becomes even weaker. Then there's the broader cultural dynamic. Political comedy has always existed. From Saturday Night Live to late-night monologues to award show hosts, presidents and former presidents have been targets for decades. Courts have repeatedly affirmed that exaggerated political satire is core protected speech. If Trump moves forward with litigation, it could become another headline, another courtroom battle, another round of motions and counters. If he doesn't, the threat may fade into the long list of social media pronouncements. At the end of the day, the legal hurdles are steep. The First Amendment protections are strong. The actual malice standard is unforgiving. The damages requirement is strict. The discovery risks are real. What remains to be seen is whether this was simply a post written in anger or the beginning of another legal fight. If a complaint gets filed, the procedural chess match will begin immediately. Motions to dismiss, jurisdiction questions, anti-SLAPP analysis, potential corporate defendants, discovery battles, and yes, depositions. Until then, what we have is a collision of comedy, politics, and the Epstein narrative, and a legal threat hanging in the air. Whether that threat turns into a courtroom showdown or quietly dissipates will tell us more about strategy than about law. If we continue pulling at this thread, the broader implications become even more interesting. Because this isn't just about one joke at one award show. It's about the tension between political power and cultural commentary in America. It's about how far public figures are willing to go to control narratives and how the legal system responds when comedy becomes the battlefield. Let's imagine for a moment that Trump does file the lawsuit. The very first step would likely be a motion to dismiss from Trevor Noah's attorneys. They would argue that the joke is protected speech, that no reasonable viewer would interpret it as a literal factual claim, and that the complaint fails to meet the actual malice threshold. Courts often resolve defamation cases involving satire at this early stage precisely because prolonged litigation can itself chill speech. Now consider jurisdiction. Where would such a case even be filed? If it's filed in a state court known for being plaintiff-friendly, the defense would likely attempt to remove it to federal court. Federal courts are often more rigorous in applying First Amendment standards in defamation cases involving public figures. Venue selection becomes strategic immediately. Then there's the anti-SLAPP question. Depending on the state where the case is filed, anti-SLAPP statutes could come into play. These laws are designed to deter lawsuits that aim to silence speech on matters of public concern. If Trevor Noah's legal team invokes anti-SLAPP protections successfully, not only could the case be dismissed quickly, but Trump might also be ordered to pay attorneys' fees. That shifts the risk calculation dramatically, and we haven't even gotten to discovery in detail. If the case survives early dismissal, both sides gain access to discovery tools. Written interrogatories, requests for production of documents, subpoenas, depositions, emails, internal communications, public statements, financial records. Trump would have to articulate under oath precisely how that specific joke harmed him. He would have to produce evidence of reputational injury or economic loss. That means financial documents might become relevant. Business performance data, licensing agreements, fundraising impacts, market reactions. If he claims damage to brand value, experts would be hired to evaluate that claim. And once you introduce experts, the case grows even more complex and expensive. There's also the question of narrative control. Courtrooms are not social media platforms. They operate on evidence, procedure, and sworn testimony. If the defense chooses to aggressively litigate, they could examine Trump's public statements about Epstein over time. They could scrutinize his prior denials. They could analyze how media coverage has already shaped public perception, independent of a Grammy joke. All of that becomes relevant to whether a single comedic remark could reasonably be said to cause new harm. Now, think about optics. Imagine a former president sitting in a deposition being questioned in detail about his associations, his business dealings, and his statements regarding Epstein, all because he filed a defamation lawsuit over a joke. The spectacle alone could overshadow the original remark. This is one reason many public figures avoid suing comedians. The cure can become more damaging than the alleged injury. There's another legal nuance here: rhetorical hyperbole. Courts recognize that certain statements are so exaggerated that no reasonable person would interpret them as factual assertions. Political humor often falls into this category. When someone jokes about needing a new island, the context signals absurdity. The audience understands it as satire. The legal system places enormous weight on context. The setting matters: a Grammy Award stage, a comedic monologue, a live entertainment broadcast. These factors strengthen the defense argument that viewers understood the comment as humor. Let's also address the practical likelihood of damages. To recover substantial monetary compensation, Trump would need to demonstrate quantifiable loss. Did advertisers withdraw? Did licensing deals collapse? Did speaking fees decrease? Did business revenue dip directly attributable to the joke? Causation is critical. You cannot simply show that your reputation is controversial. You must show that the specific statement caused measurable harm. And in a media environment saturated with reporting on investigations, lawsuits, and prior controversies, isolating harm from one punchline becomes extremely difficult. Then there's the political calculus. Legal threats often energize a supporter base. They reinforce narratives of media bias or persecution. Even if no lawsuit is filed, the act of threatening one generates headlines and loyalty signals. Filing, however, creates obligations, pleadings, hearings, procedural deadlines. It's possible that the threat itself achieves the desired effect without incurring the risks of litigation. We should also remember that comedians frequently respond to legal threats with more jokes. If Trevor Noah feels confident in the law, he could double down. That could escalate the cultural moment. It could turn into a broader debate about free speech, satire, and political sensitivity. The First Amendment was designed to protect speech that is provocative, critical, and even offensive, especially when directed at powerful public figures. The Supreme Court has consistently reinforced that principle. So where does that leave things? Right now, we have a social media post, a legal threat, and a lot of speculation. No complaint, no docket number, no scheduled hearings, just rhetoric. If a lawsuit is filed, it will likely face immediate constitutional challenges. If it survives early dismissal, which would itself be surprising, the litigation could open doors Trump may not want opened. If it's never filed, it joins a long list of threats that functioned more as messaging than as legal strategy. Either way, the episode illustrates something bigger. In America, politics and comedy constantly collide. Public figures are mocked. Comedians push boundaries. Courts step in only when clear legal lines are crossed. And those lines are intentionally high when the plaintiff is a public figure. What happens next depends on whether this was an emotional reaction or a calculated move. If paperwork appears in court, the real battle begins, not on social media, but under oath, in front of a judge with constitutional law at the center. Until then, it remains a dramatic aftershock from a Grammy punchline that hit harder than expected. If we take this even further, there's another layer that hasn't been fully explored yet: the strategic consequences beyond the courtroom. Because lawsuits involving high-profile political figures don't just operate in a legal vacuum. They reshape media cycles, influence campaign narratives, and sometimes backfire in ways that are hard to predict. Let's talk about precedent in political defamation cases. Public officials and public figures have tried for decades to use defamation law to silence critics. Very rarely does it succeed. The landmark case of New York Times versus Sullivan set the bar extraordinarily high for public figures. The actual malice standard isn't just difficult, it's intentionally difficult. The court wanted to protect robust political discourse. That includes exaggeration, satire, and biting commentary. If Trump were to pursue this lawsuit aggressively, it could trigger renewed national debate about weakening or overturning the actual malice standard, something he has openly criticized in the past. Some conservative justices have signaled openness to revisiting aspects of defamation law, but overturning decades of precedent is no small matter. It would require a case that squarely presents the issue and survives lower courts. This Grammy joke case would be an unlikely vehicle for such a constitutional shift. Now consider the ripple effects in the entertainment industry. If a sitting president or former president successfully intimidates a comedian into silence through legal threats, that creates a chilling effect. Networks might become more cautious, writers' rooms might self-censor, award shows might tone down political humor. But here's the counterpoint. Historically, attempts to silence comedians often amplify them. The Streisand effect is real. Trying to suppress speech frequently draws more attention to it. If Trevor Noah were to fight publicly, it could strengthen his brand as someone defending free expression. Then there's the political symbolism. A president suing a comedian over a joke sends a certain message. Supporters may interpret it as strength, someone who refuses to tolerate attacks. Critics may see fragility and inability to handle satire. Independents may view it as a distraction from governance. Public perception doesn't hinge only on legal merit, it hinges on optics. There's also the fundraising angle. Legal battles energize political bases. Campaign emails practically write themselves. They're attacking me. They're mocking me. Help me fight back. Even without filing, the mere existence of a controversy can be leveraged for political capital. So the question becomes, is the goal legal vindication, financial damages, or narrative control? Because those are different objectives. If it's narrative control, sometimes filing a lawsuit can actually undermine that goal. Court filings are public records. Motions to dismiss are public. Transcripts are public. Depositions, if unsealed, can be public. Journalists comb through those documents line by line. And once you're in litigation, you don't control the timing anymore. Judges set schedules. Opposing counsel sets traps. Deadlines are mandatory. Another factor to consider is jury dynamics. Even if such a case somehow made it to trial, which is statistically unlikely, juries are instructed to consider context. They are told to assess whether a reasonable person would interpret the statement as fact or satire. A Grammy monologue filled with jokes about multiple political figures would strongly signal comedic context. Now imagine the defense playing the full clip for the jury. The laughter, the tone, the pacing, the exaggerated setup. That matters, and if the case is dismissed early, which is probable, it risks reinforcing the perception that the lawsuit was weak from the beginning. Let's also touch on the possibility of counterspeech instead of litigation. Public figures traditionally respond to satire with more speech, interviews, statements, jokes of their own. That's the marketplace of ideas at work. The First Amendment presumes that more speech, not lawsuits, is the preferred remedy for offensive commentary. Litigation is the nuclear option, and nuclear options come with fallout. There's also the question of institutional response. If CBS or another network is named in a lawsuit, they will likely defend vigorously. Large media corporations have experienced First Amendment counsel. They've litigated defamation cases before. They don't settle lightly when they believe speech is protected. If anything, a major network might welcome the opportunity to reaffirm legal protections for satire, and we can't ignore timing. With midterms approaching and numerous other political controversies in play, pursuing a defamation lawsuit could distract from policy messaging. Court hearings compete with campaign stops for media attention. Every hour spent on litigation strategy is an hour not spent on voter outreach. Finally, zoom out even further. This moment reflects a broader tension in American democracy, the friction between power and humor. Political satire has existed since the founding era. Presidents have been lampooned in newspapers, cartoons, television, and now social media. Some embrace it, some ignore it, some bristle at it. But courts have consistently treated satire as protected. So what happens next? If no lawsuit is filed, the moment fades into political theater. If one is filed, it becomes a constitutional test case, though likely a short-lived one. Either way, it underscores how intertwined law, media, and politics have become. One joke at an award show has now opened a conversation about defamation standards, presidential temperament, First Amendment protections, and the limits of satire. And the most important takeaway might be this. In the United States, comedians are allowed to aim upward. The higher the office, the stronger the legal shield around criticism. Whether that shield is challenged or left alone depends on what happens after the threat. For now, we wait to see if it was just another headline, or the beginning of a courtroom showdown that could test the boundaries of political speech once again. If paperwork appears in court, the real battle begins not on social media, but under oath in front of a judge with constitutional law at the center. Until then, it remains a dramatic aftershock from a Grammy punchline that hit harder than expected.